the seat of criminal activity in this country.
I don't think there's any allegation of that in this case.
But once we say no criminal liability, Mr. President, you can do whatever you want, I'm worried. That we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you another question. Let me ask you another question about this clear statement line of questioning. First of all, I didn't see you argue that below. I don't know, I understand that you have that set of in your briefs here, but did you you use that argument to avoid constitutional questions. You are asking us a constitutional question here, so it doesn't even make sense to talk about clear statement in rule the way that it's come up in the context of an immunity question. But let me ask you this about it. I had one more question. Yeah, so what is the argument that the President of the United States, who you say is bound by the law, is not on notice that he has to do his job consistent with the law? I mean, to the extent that the clear statement rule comes in at all, it's about the person not being on notice. So I guess I don't understand why Congress in every criminal statute would have to say, and the president is included. I thought that was the sort of background understanding that if they're enacting a generally applicable criminal statute, it applies to the president just like everyone else. So what is the clear statement that would have to be made in this context?
Under Franklin and under Public Citizen, Congress has to speak clearly before it interferes with the president's powers, and we have here an indictment that seeks to criminalize objective conduct that falls within the heartland of core executive authority.
Thank you.
Thank you, counsel. Mr. Dreeben.
Mr. Chief Justice, and may it please the court. This court has never recognized absolute criminal immunity for any public official. Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. I welcome the court's questions.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article II branch, can assert, as applied, Article II objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions.
Yes.
Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the Attorney General, and it would be a due process problem to prosecute a president who received advice from the Attorney General that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
Well, the Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said, but there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in the some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So well, I don't want to overstate Your Honor's concern with potentially relying solely on good faith, but that's an ingredient, and then the courts stand ready. The Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case, neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance. Want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity.